Let's see. Check 1 2, check 1 2. Okay, you should be hearing me now, hopefully. All right, great. Fantastic. Okay. Sorry about that. Anyways, we were here with Darrell Brooks this morning. I had to restart my stream voice mod thing. But we made it work. Now, let's see. Style design. No audio from the court yet. Let's see. Name. Yeah. Apps. Widget. Chat box. Okay, so I can readjust this chat box. It's a little bit big. There we go. That works. Put it in that corner like that. Great. All right, cool. Excellent. All right, yeah, I'll restart that. Sorry about that. I don't want you to miss him shuffling the papers. Okay, anyway, so we're here with the continuing Darrell Brooks trial. And Darrell Brooks may call his mother today. His mother is not under subpoena. So his mother would have to show up voluntarily. So did he call his mother over the weekend? Did he ask her to come? Will she show up? Who knows? That'll be exciting. If I'm the prosecutor, quite a few questions are going to revolve around what is your son's name in various forms. You know, obviously, since that's been a huge issue of contention. We'll ask that like 8 different ways. Okay, and then whether or not his mother shows up, okay, then we have, of course, the big question for the day about whether or not he will testify, in which case that cross-examination could be quite lit. So here's what's happening. So we have possibly his mother, depending on whether or not his mother shows up or not. Possibly him, but probably. And then we're going to, so we're getting about a half day, maybe. And then we're going to get into jury instructions, which will take the remainder of the day. We may stream some of that. We may not stream all of it. We'll see how it goes. And then tomorrow, the jury will get the instructions. That'll take probably 2 to 3 hours to read because there's so many of them. And then we'll have closing arguments from the parties, which, 2 hours I would expect. So the jury gets the case by lunch. The jury convicts by tea time. And everyone goes home except for Mr. Brooks. And then, of course, we'll probably have sentencing in 1 to 2 months, formally. And then he can appeal. And the Court of Appeals can be like, I see no grounds of appeal during the trial. I've said no grounds of appeal during the trial. So maybe there's some pre-trial stuff you could appeal. Obviously, if the state withheld anything, Brady violations or some other defect somewhere, but I've seen nothing during the trial itself. So, yeah. And also, some of those pre-trial stuffs may not have been preserved at this point because Mr. Brooks, doesn't know how to preserve issues. So some of that stuff, even if it did exist, might have been lost along the way. So not everything is going great. Does he get to represent himself and yell at the Court of Appeals too? Yeah, on paper he does. But I imagine the Court of Appeals will decide this on paper.
Wisconsin versus Darrell Brooks, case number 21 CF.
Guys, can you hear the audio okay of the stream? It's a little low, I know. Turn this up a little bit. Oh, no, that was muting. That's the other way around. No, stay on. On audio. No, on. Thank you.
Charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights.
He says he doesn't dispute any of the facts in the charging instrument.
All rights reserved.
Guys, that right along is just basically a plea of guilty. I don't dispute any of the facts in the charging instrument. It's just pleading guilty.
A suit and tie and a mask.
I mean, he says it every time, but I'll still make a note of it. I don't fight any of the facts. So you admit to all the facts. So you're guilty.
Do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called.
I know you don't, Mr. Brooks.
Do you anticipate calling any witnesses today?
I don't believe today.
Today's the only day.
We are here for the continuation of testimony. The only witness that I'm aware of that's on
His mom
the
didn't
list
come. Lol.
that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked.
Inmate communication something is on ICS.
Actually, I just went to you and then went to the prosecution.
It's an email, basically, for all intents. I think. I'm not exactly sure, but whatever. It's an inmate communication, whatever.
The audio's on.
In communication form, so it's ICF? Okay, fine. In communication form, fine.
Do you know when you sent those?
Saturday.
I'll put up the audio a little bit for you guys.
So that would have been the 22nd.
State receive anything through, like, the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection?
From you, sir?
No objection. I definitely want those documents received as they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are two ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
Super duper important, I'm sure, yeah. I'm sure these documents are just the most important documents ever. Maybe he filed a motion for continuance or something like that would actually make sense. Maybe that's what's going on. I don't know. I mean, we can only hope. Not that it would be granted, but, you know, maybe it makes sense. He filed for like a 24-hour continuance because something. I don't know.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
Right. You got a Brady violation? Sure you do.
All right, what information make an offer of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify.
She's on her game. She knows the
that
issue.
Does not prevent the brake
Good for her.
working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue. And
It's
I
moot.
actually have,
It's very moot.
the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the
Yeah, Drexen, that's what he said, but
2000
apparently didn't happen. So yeah,
Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens.
right. At which point we inspected it, and there's nothing malfunctioning with the vehicle. We did the inspection.
Seeing
We
as
we looked.
a class action lawsuit,
Right, but
no one would
you see the
sue
thing
a
is,
Ford company.
we
if
actually
there
did the
weren't
inspection,
malfunctioning vehicles. There would
and
be
we
no
determined
class
that
action lawsuit
the car was not flawed,
if these vehicles were
and
not
it didn't lead to this
malfunctioning.
problem because we looked.
I believe with
And
that,
no,
like I said, the information.
so some
is
vehicles
easily
may have this
accessible.
problem, possibly.
I should
but
have the information.
not
in the
yours.
mailroom right now
So
that you can.
also, it's not a
readily
Brady
view
violation
this information
because
about the class action
we told
lawsuit,
you all
about
these
the recall
things
on-
in the
it wasn't
report,
just the
which
2010
we
model
obviously
in
turned over to
question.
you.
2008
So,
through
no.
2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address
Call
your
for
claim,
it.
sir. So, not trying to cut you off, I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note
That
that
too.
you had a full and fair opportunity to cross-examine the inspector regarding
That too.
his
I
mechanical
missed that part of
inspection.
it, but yeah, it's easily
It's
findable.
not
So
new
you knew.
information. And more
Great.
importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said.
Just one page,
I have to turn
low.
my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your
Hold
Honor.
on, let me finish my record, okay? So I'm gonna turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case.
Please watch 9 hours, 19 minutes from Friday.
Witness.
We watched Friday. We don't need to watch it again.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information.
Okay, so you
My
had the
mother gave me
information.
the information.
So you had the information.
I had no knowledge until she told me.
Okay, but you had the information.
That's how I came into the information, and she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I didn't.
I understand that, sir,
this
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record.
It was just,
Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your
$2.
case. The fact
I get
that you have
recalls
now
for other
learned
people's
this,
Hondas all the time.
it's a little
True.
bit too late, and I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
going to
you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
from the state
addressed,
that
Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right.
Subject matter
I
jurisdiction needs to be
respectfully
respected.
I respectfully object, Your Honor.
Why
and
isn't this
request a
alert
legal
going away on screen? This is
reconsideration of your
bothering
ruling,
me.
Your Honor.
It's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
Exception's actually the right
Mr.
word.
Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For the
can't
record, may
answer
I
that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction.
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
Noted.
Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
She's right.
So you're
right.
denying a legal, you're denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
Tell the Court of
Mr.
Appeals
Brooks,
about
we're
it.
going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor?
It is, I assure
Show me that
you.
it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It doesn't
advisements, and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to give you advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will be
you're holding me in
removed
contempt
to
again.
the
No,
next
she's
courtroom
never held
so
you
that
in
I can
contempt.
properly go through these advisements
And
without
I
being
still,
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr.
No,
Brooks,
no,
I've
she's
not held
not.
you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with
I
all
need
due
you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You
I'm
are
merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple opportunities
You're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt
Mr.
No,
Brooks,
she's not.
I'm
by
not holding
removing
you
me
in
from the
contempt
courtroom.
for the
No,
second
she's
time
not
here.
holding you
I've
in
also
contempt.
repeated that.
Your Honor,
He's
with all-
interrupting
The lawyers
me
in the
yet
room
again.
said-
Mr.
With all
Brooks, I
respect.
need you to stop talking.
Throw her
all
out.
respect.
Throw him out. Throw him out.
Illinois
Just
versus
do it.
Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to
No, he's not.
disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
standards
because
of
it
form and
doesn't.
civility, and
Illinois
one of the
doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It,
Again, I'll
it
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
Well, my friends, we're off to a great and promising start, aren't we? I think we're off to a great and promising start. I know you do too. Oh, I got different camera modes. Ooh, I can do all kinds of fun things. Okay. What does this one do? No, that's no good. How about this one? Nah, that's not really good either. Don't like it blocking my face. Lol. Yeah, we'll make do. I'll just scoot over this way. How about that? All right, great. All right. So yeah, this is going great this morning. It's just going all the wonderful. It's going all the great, just fantastic over here in sovereign citizen land. Guys, don't do drugs. Don't become a sovereign citizen. These are good life lessons from me to you on every possible level. Nothing he's saying makes any sense on any level at all, except, he's actually kind of making he's making a tenth of a cogent argument on the whole Illinois versus Allen thing, but we covered that. We discussed that on my channel already in depth, so we don't have to go into that. But yeah. So yeah, and the judge is like, yeah, I need to do the advisements. And so, yeah, his mom didn't show up. His mom didn't show up is what we've learned. So yeah, his mom was not under subpoena because he didn't write one. And the state had withdrawn. The state had withdrawn their subpoena because they had subpoenaed the mom at one point and then withdraw it. Right? They subpoena all the witnesses and then they decide which witnesses they want, and then they withdraw the subpoenas for the ones they don't want because why have a witness show up that you don't want, right? So like, yeah, that's pretty typical. You subpoena all the possible witnesses basically to give them notice that they might have to show up, right? So you subpoena, 80 witnesses or whatever. And then, as you get closer, you withdraw the subpoenas that you don't need because you don't need them, but you want to give them notice. You want to give them as much heads up as possible under the circumstances, out of courtesy, if no other reason, right? So anyways, so the state withdrew their subpoena. Brooks failed to write a subpoena. And so his mom could have voluntarily shown up, right? It's not required that there be a subpoena. I mean, because obviously anyone could show up at any time, right? So his mom could have come, but not so much. Apparently mom doesn't want to be there, or Brooks didn't ask, either way. So now we're moving into the do you want to testify on your own behalf discussion on the record. And the judge is going to give all kinds of advisements to which Brooks is not going to have the earphones in his ears. We all know this in advance. Let me just tell you the future. Right. He's not going to have the earphones on. And so he's going to pretend not to hear and stuff. And so he's going to refuse. He's almost certainly going to refuse or be continuing to be belligerent on the whole thing. So I don't know whether or not he takes the stand. I think the odds are he doesn't take the stand. I think his desire for disagreeable confrontation will supersede his narcissistic desire to be center stage. So that's my prediction. I think actually maybe Brooks won't take the stand because I think he won't, and then he's going to complain about it, about how how they denied his right to take the stand and stuff. And the Court of Appeals is going to continue not to care about any of these things, because the judge is, as always, bending over backwards to give him every possible opportunity. And so a defendant cannot be compelled to be a witness against themselves, right? That's the Fifth Amendment. A witness cannot be compelled to be a witness against themselves, or a defendant cannot be compelled to be a witness against themselves. So if he refuses to say whether or not he wants to testify, the judge can't say, okay, the default answer is you testify, because that would be compelling, right? It's you have the right not to testify. You can waive that right, but you have to waive that right. Otherwise, you have the right. So the judge is going to assume, quite rightfully, that if he doesn't make an election, he's electing not to testify, because you can't say, well, in failure of your decision to make an election, I'm going to decide you have to take the stand. That'd be like a defendant refusing to plead guilty or not guilty, and the judge saying, okay, well, since you refuse to plead, I'm going to enter a plea of guilty. It's no. It's innocent until proven guilty, right? So it's yeah, you can plead guilty, but if you refuse to plead, the judge will enter the plea of not guilty on your behalf. So same thing, right? It's if you refuse to say whether or not you're taking the stand, the judge will be okay, well, you're not taking the stand then. Violate my right. No. Nothing that's happened in this trial, during the trial phase at least, has violated your rights or come anywhere close to anything resembling a violation of your rights. The judge has gone out of her way, in every possible way, to preserve your rights. Not that you have to, because the judge could treat you the same as a lawyer, right? That's, you're subject to the same rules. Now, most judges will give pro se's some additional latitude, right? So, I mean, most judges, including yours truly, if I were a judge, would give a pro se a little bit of extra slack because, we're not going to make you do things in quite the right formalities, right? So, like, if you say one thing, but it's like, well, what you probably meant was this, I'll reinterpret your motion, or, it's like, well, you said I moved for this, but what you really meant was move for this, and I'll consider that, right? So I'll give you like slack. I'll try to figure out what you really meant to do. I'm not going to make you quote the Latin or something like that, right? So I'll give you a little slack. But, this judge is giving so much slack, so much more than they actually have
Please
to.
get verification that the audio and video are working in the neighborhood.
The whole thing is hilarious.
All right, thank you. I do have verification.
And she won't.
There are headphones on the table in front of Mr. Brooks. Should he choose to wear them?
He just tossed him aside.
I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising
Bible.
his voice,
So we can hear. He shows up the book he's reading. See, he's reading from a book, and he shows the book, so we can hear.
That I made after the fact. Just this morning alone.
Back to the center of the screen.
About 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness. He then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before
I'm not sure why he's holding up the Bible. I'm not sure what he thinks he's doing by holding up the Bible.
Mr. Brooks has, by his conduct, forfeited his right to be
I mean, he'd be
present
slightly
on a
better off by
number of
holding up a copy of the U.S.
occasions
reports
due to
or
his
something, right?
conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need
Thank
to
you,
go
Jake,
through,
for your
and
$99.99 super
simply
chat.
am not able
That's
to
an
do
incredibly
that
generous
with
super
him
chat. Thank you very
constantly
much. Happy belated
interrupting
Texas
me
bar passage, and
then
thanks for all your do.
not
Thank you very much,
respecting
Jake. I am
the
happy to
rulings
report
are
that I have,
made.
as of yesterday,
Of course,
completed
at
the
any
Texas
point in
bar
time, Mr.
supplement
Brooks
thing
can ask
I
be
had to
brought
do.
back over to
It
this
was 12
courtroom.
hours of pain.
Under
I'm glad it's
Illinois
over now.
versus Allen, of course, he needs
And
to
I should be sworn in on
pledge
November
that
14th,
he
which is very
is
exciting, and I
willing to
appreciate your
conduct
very, very
himself
generous super chat. Thank
consistently
you.
with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided.
The 12
by the
hours
state's case, he
of
was in the
bar
courtroom,
supplement,
if not during the
I
entire
think,
time,
without
he was able to
exaggeration, was
cross-examine
the hardest part
witnesses.
of the entire
We had a
experience.
couple of issues during the
I'd rather just study for the bar
testimony
again.
of
It
witnesses he called.
was pretty
And
bad.
of course, last Friday was, in my
It
opinion,
was,
probably one of the most challenging days.
mind-numbingly safe in his
challenging
presentation,
days, I
as
should
is
say, to
typical
date.
of these kinds of things.
It's
And,
my
oh
hope
God.
that we can continue with Mr. Brooks in this courtroom at some point today.
My
I'll
face isn't
certainly
covered up with a
invite him
Bible.
back
Hold
over,
on. I think I can fix
when
that.
I
Give me a
get
second.
through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we address the subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity. You will forfeit the opportunity to call.
Thank you,
any
E. Caroline,
other
for
witnesses
becoming a
on
member.
your behalf
10
other
months
than
of membership,
yourself.
thank
So I
you.
will ask you one last time, sir. Do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted.
You've been
sir.
unmuted the whole time, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court, because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I
He said
trust
that.
that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now?
Is she here?
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir. I've
You are
confirmed.
lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has.
I don't remember
asked
this
him
as part of that
3
rap
times if he
thug
had any
life
additional
thing. I don't
witnesses to
remember the
call.
acting
I
like a
warned him that if he
petulant
did not
little
answer that
child
question, he would
being
forfeit
part of
his
that
right to
rap
call
thug
additional
life.
witnesses,
I don't
other
remember
than
that
perhaps
part.
himself. I then specifically asked him about
where's the
Dawn
what the
Woods,
business guy?
because that is the person he indicated he wanted to add to his witness
This is
list
the
last
business.
week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself.
$5 from Daniel.
I'll
Why don't
find
we
that he
give
has
judges the authority to
forfeited
find
his
defendant
right
like this
to
guilty
present
instead
and
for
call any
cooperate?
additional witnesses
It's
based
against the
upon his
Constitution,
conduct
but I appreciate your
in
sentiments.
this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves
Amy and
a
Bossa gives
witness
$2.
in their
Thank you for
own
making a
case.
day of
They
programming
talk at
tolerable. I
length in
try
that case
in what limited ways
about
I can.
how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon.
Thank you, Daniel, for becoming a member. Appreciate it.
conduct.
Thank you.
Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence.
Thank you to
the
everyone
rules
who
of
hits that beautiful
procedure,
join button.
And also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's
$2 from
right to
Andrew says, I
present a
trust my
defense,
8-year-old
this
nephew as a
court
lawyer
must
before this
balance
guy.
that with
I think you got it right.
preservation of dignity, order, and decorum.
Or
and the numerous
$4.99 from
procedural and
Watermelon.
evidentiary
Walter
rules
Melton.
that
Uncivil
control
as
the
promised the
presentation
business.
of evidence.
This is not the business.
Because
We're the business.
in my findings today,
Yeah.
Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has
Midnight Drury, thank you for the 5 gift
forfeited
memberships.
his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Burke, you're unmuted.
He's unmuted.
You're unmuted. You can speak for everything you want, but you're not to hear any hear that.
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
She's explaining it for the record, by the way, when she says stop explaining
Mr.
everything.
Brooks, I would like
She's explaining
to
it for the
go
record
through
because the
with
Court of
you
Appeals
your
goes off
right
writing.
to testify and your right,
Right,
not
so
to testify.
she needs to make
We are at
clear
the
that he
stage
can
in the
hear, that it's
proceedings
loud. She needs to
where
make that
it is
all
important that
clear
this
because the
court
Court of Appeals
conduct a
goes on the
colloquy
written record. They
with
go off what's in
you.
writing.
I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again,
if
that's
this
State
works. I
versus
click this.
Anthony, 2015, Wisconsin.
Ooh,
20.
that's pretty cool.
Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that?
No response?
There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
Thank you. Just a small town girl. Appreciate it. Just a small
No
town
response by
girl.
Mr. Brooks.
Living in a
Sir, you
lonely
also have a
world.
constitutional right
Giving
not to
$10 of
testify.
super chats going to
If you decide not
Uncivil
to
Law.
testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
Probably not. You know, being in prison and all,
Not
but you
receiving
know.
a response to that.
Thank you,
I'm aware
Katrina,
that
for the
he's able to
$5.
read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted,
You've been unmuted the entire time.
sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you gonna verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24
Just keep going.
hours.
Just keep going.
I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, "What did you say?" Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
So
Put on the earphones if you want.
I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear, and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
Yeah.
Mr.
So
Brooks,
she's
you
saying
may-
all that for the record, right? That she's
You
saying
are,
based
sir.
on my observation, he's
And I'll
feigning
make a
it.
record that per the lieutenant
She's
over in
so
the
she's
other
making
courtroom,
findings
the
of fact,
volume is
which
2
she
to
can
3
do,
times louder
right?
than
Because it's
it
not a
is in
finding
this
of fact that
courtroom.
goes to any element of the crime.
False record saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have
Or
an
can
issue
hear
hearing
me
you
when
at
I'm
all,
right
sir.
here? Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Keep going. Good for you.
Have you made a decision to tell
I
me
will
if
ask
you're
you
gonna
again,
have
sir.
subject matter jurisdiction?
Have you made a decision to testify
Have you made a
in this
decision to
case?
address subject matter jurisdiction? Have you made a decision to be impartial?
Third and final
Answer
time,
what
sir.
your name is?
Or waive it.
To answer if you have a claim against me or
I'm
don't.
going to
you
mute him
have a
for the
claim
moment
against me?
just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with
He
him
is trying to
regarding
provoke
his
a
right to
mistrial. You're absolutely
testify.
right, but he's not going to do it because the
asking me
judge is
about
too smart
subject
for
matter
that.
jurisdiction.
The
He's
judge is
making
too smart for
statements
that.
about
The judge
this
is
court
keeping
that are
her cool.
disparaging and about
Better
my
than I
oath.
would.
Again, a clear
Not
attempt
necessarily
in my
to say that she lost her cool would be a
opinion
mistrial,
to
by the
simply
way.
stall these
She
proceedings
could go a
and to
lot
disrupt them.
further, and she could get angry and
I
it not
will
be a mistrial.
unmute
The judges
him,
have a
and
lot
I
of
will ask
leeway,
him for
but
a
she's
third
playing
time
it
with the
on the safest of the
understanding
safe
that if
ends.
he fails to answer the question in the affirmative, I will interpret his failure to respond as a no, and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case?
So no.
There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted? Am I unmuted?
Yes, you have been. Sir, do you want to,
How long have I been unmuted? 'Cause you just
sir,
said-
do you want to testify in
you
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You
Just
said-
say, I'm interpreting it as no, your case is closed. Just close it, just do it, save us all the trouble.
In the first place.
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to?
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court,
Do it.
as I indicated earlier, is tasked with the
Do it.
duty
Do it.
to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer.
Thank you for the
simple
2,000 of you who are
questions.
watching, by the way, for this crap show of a
I
trial.
personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone he is yet to
Thank you,
conform
Brent, for the
his
5 gift
conduct
memberships.
to the simple standards
Or
of
50,
courtesy
actually.
and decorum.
Sorry, it was a little bit
that
off screen.
are
50
required
memberships.
of
That's very
all
generous. Thank you.
participants in these court proceedings.
readjust the border so I
court,
can see it more
the
clearly.
prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right.
I knew it was too early for the Final
testify
Fantasy victory
by
sound.
his
I knew it
own
was too early.
conduct.
I wanted to press the button because she said it forfeited the right, but I knew it was too early.
Such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand, no. I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully
Sure.
choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect,
Just keep going.
You've been trying
Did
to
you hear me say
answer
that?
questions for me. I didn't hear you ask me anything.
Uh-huh.
And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one last
headphones on.
time.
Yeah, I can hear them. I got the headphones on.
All right, then let's...
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction.
stating
He
the
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
Bruh.
law without a license.
Bruh.
Again, all
No, I
attempts
said
to
practicing law
deflect
from the
away.
bench. I
I'm
said
going to mute him
practicing
once
law.
again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions.
And he takes off the
confirming,
headphones.
on the record that
Lol.
he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through the questions
Emotional
once again,
damage.
that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that
Yeah,
or not.
apparently his mom did refuse to come. Yeah.
And based upon
Lol.
pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely
he
no
can't get a new
regard
trial.
for
He's done.
courtesy and decorum.
He's done.
He is what I would describe
He's
as
done.
a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter.
You got it, Secret Mix Girl. Let me just make those
regard
changes
to the
real
rules
fast.
of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right.
Yeah, I think the appeals
testify
court is
by
going to
his
laugh pretty
conduct,
hard when they get
whether
this.
a criminal defendant may
I wouldn't
forfeit
spend any
his
time
or
on
her
this
right
as
to
the Court of
testify
Appeals.
through
I just write
conduct,
judgment affirmed, probably, and just call it a
incompatible
day. I
with the
can't be
assertion
bothered
of
with
her
this. I have other things to do with my time.
was
Actual
reviewed
cases that
by that
actually merit
court.
my actual attention.
That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against
He'll probably spend the rest of his
Mr.
life
Brooks's
thinking he
right
got
to
cheated by the
testify.
system or something.
This court is not
Man, I got
making
cheated
an
by the
arbitrary
Rude
decision.
Jack.
The decision I make here
Oh,
today is,
chamber,
in my
kangaroo.
opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And is for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
No.
We have no rebuttal case, Your Honor, thank you.
All right.
Yep. No, we're good. Thanks.
I'd like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir,
You're trying to, you asked me a question, now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer.
She is protecting your constitutional rights. She protected them. She protected them as much as she could.
You can't make a decision for me.
Yes, she really can. She really, really can.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do.
Just keep him there. Bring the jury back. Just keep
you
him there.
willing
Just
to-
keep him there.
Your Honor.
Please, for love of God, just keep him there.
Not coerce me.
Please.
I'm not coercing you, sir.
Please.
Well, you're making a decision for me based on something
Please.
that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense. And then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
Go suck a dick! suck a motherfucking dick, suck a huge or small.
Yep. Well, this is going just great, guys. This is going great. It's everything you wanted to do. So, Mr. Brooks does not take the stand, nor does his mother. The case is over. Very sad for everyone. Oh well. We don't get to hear the greatest cross of all time. We don't get to hear the state asks his mom 10 different ways. What is your son's name? Do you have any children? Yes. What are their names? Darrell Brooks. Is he here? Yes. Could you point him out? Yeah. How'd you get the name Darrell Brooks? Well, I called him when he was born. How long has he gone by the name Darrell Brooks? Since he was born. Has he ever not gone by the name Darrell Brooks? No. Does he recognize being called the name Darrell Brooks? Yep. All the time. Sadly, we do not get to hear those questions and answers, but oh well. Instead, we get the judge actually, for once, actually imposing some actual discipline. That's nice. So, you know, thank you for that. Way to go, Judge. We appreciate it.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day. That brings it I'll go through all the jury instructions, and I anticipate bringing them in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. They'll get them back to you during deliberation.
What an ass. What an absolute ass. He deserves everything that's coming to him. What a total dickwad. What a total dickwad. So there's some chance the jury might not get this tomorrow. I don't know, man. I think they'll get tomorrow because I don't know if Darrell Brooks is going to give a closing. I doubt it. State's going to give their closing. Darrell Brooks is going to like go on a ranting rave, be thrown out, have his closing forfeit. State won't give a rebuttal. I think jury's getting this tomorrow. It'll take 2 or 3 hours to read through the jury directions tomorrow because there's like 77 counts. So that'll take a little while. Cause also lesser included and stuff. So
Mr. Brooks to come back over.
Lol.
And then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
Well, guys, with them coming over again.
Oh shit! Here we go again.
Yeah. So the case is over. There is no case. It's all gone. Case is all over now. So case is all over. So fun and exciting. Wow. Let's see. Soundboard has gotten a little overkill in my opinion, Kurt. I like it in fine doses. Maybe tweak the volume a bit. I keep having to change my volume controls. Yeah, I mean, you know, the volume levels and stuff is problematic because, you know, when you're using these web software tools, because the audio management tools within these web-based platforms sucks. But I wanted to use a web-based platform in the chance that I wanted to invite someone over or something. So yeah. So you know, we're all good. We're all good. Let's see, settings, quality indicators. Yeah, we don't need quality indicators. Great. Ah, man, good times. Yeah, the proper use of the soundboard is something obviously that requires some experimentation on when to use it and when not to use it. But you know, it's a brand new tool. Like all tools, we must learn how to use it properly. We learn by experimenting on you, the chat. You are my guinea pigs. Congratulations. You're here as I learn. You're actually my guinea pigs for all the things. I don't know if you realize that or not, but you know, now's as good as time as any. Yeah, you're my guinea pig for all the things. You're my guinea pigs for things like the lighting and the background. You're my guinea pigs for things like the audio management. You're my guinea pigs for things like voices to use on the box or not. And my guinea pigs for chat. And my guinea pigs, you're just my experimental tools. Lol. You are helping me become a better streamer with every passing moment. And I also now have a random button that does random voices. And I can't even hear myself when I do the random voices. Should we do a random voice? All right, let's see. Now, can I at least see what voice I'm doing if I do this? Let's find out. Let me press the button of joy and see what happens. I've never used this button before. Okay, so apparently I am Spaceman now. Is this doing anything for anybody? Is this working? Am I a spaceman? Are you feeling the spaceman button? Yes, distortion is too loud. Sounds like the police ringing it. Ground control to Major Tom. 7, 6. Commencing countdown. Booster rockets on. This is Major Tom to ground control. I'm opening the door. Floating in a most peculiar way. Okay, let's press the button again. Now I'm a cop. Hello, everyone. Uncivil Law, you are under arrest. Press the button. Punk. I'm not sure what punk sounds like, but hopefully it's entertaining. Apparently this is the soundness of punkness. Are you feeling the punkness? Is it punkness to you? I don't know. So anyways, we have a button. We have a button to just activate a random voice. So if we get bored, we just push the button like this. And now suddenly I'm talking like T-Pain, apparently. That's exciting and fun. Everyone likes hearing T-Pain. So, Uncivil Law's T-Pain, I'm sure it just sounds super, super great. I have too much power, guys. That's the thing. I have too much power. And that's what we're doing. So hopefully that's working for you, because that's what's happening now. Good times. Is there a black voice? I don't know if there's one of those or not. Is the Darrell Brooks thing over? The evidentiary phase is over, thank God. So today we're going to have a very, very painful, very long conference on the jury instructions, which, you know, is not going to go to plan because he's going to bitch and complain. I didn't get my right to testify. I get my right to testify. How can you force me into my right? You're trying to compel me into silence. The Court of Appeals does not care. The Court of Appeals does not care. I am an appellate-minded guy. You guys know that, right? The appellate law are the things I care about. I care about appeals, and I'm telling you, I cannot be bothered to care. I cannot be bothered to care about any of the things that are happening in this trial. I put on my Court of Appeals hat, and I'm still like, I do not care. I don't care about one thing that's happening in this trial. You know? So it's like, say what again? Say what one more goddamn time. That's how I'm feeling right about now. I'm wearing my Court of Appeals hat. I cannot be bothered to care about any of these things. And even if I did care, his rights are being preserved in every possible way. His rights were preserved. He chose to waive them by his conduct, which, you can do. And so the judge went out of her way. The judge really only has to tell him once, strictly. But she gave him every possible opportunity, man. When are closing arguments? Closing arguments are tomorrow. So, Detective Seed says, congrats, folks got to see a sovereign citizen strategy. If you want some company, I'll be free in a little bit. I'll keep that in mind. I can't have that very many guests on, unfortunately, in this particular streaming software. I think I can only have one guest on at a time. Why is she bringing him back in, though? There's no reason not to, really. I mean, to try. I mean, under Illinois versus Allen, she's supposed to, try to have him be part of it, and basically she's just trying to extend him his rights, even though he continually wants to throw them in the court's face. He just wants to throw, any chance of appeal just because Wisconsin's so woke. I'm going to say no. I don't see any chance of appeal because this judge has just gone absolutely out of her way in every possible way. And this is not your case for wokeness. I mean, this is not the case you want. I don't think anyone wants a piece of this case. Yeah, there are a lot of people streaming at the same time, Andy. We're all streaming this shit show at once. Can we do CLE at the same time? Thank God I finished all my CLE requirements. I finished them yesterday. Thank God I finished the Texas Law Supplement. So that is done. It was really, really painful. I don't know that I learned very much of value, to be honest. I can tell you that if the owners of the well fail to plug the well when they're done with it and they can't be located, that the state agency that's responsible for plugging the wells is the Texas Railroad Commission. Okay. That was valuable information in my time. Wells, when they're done, need to be plugged. The owners have a duty to do it. If they can't be located, the state agency that does it is the Texas Railroad Commission. All right, that's interesting, I suppose, on some level. Okay, railroads and also plugging wells. Okie dokie. I can tell you some things that are interesting in criminal law that are a little bit unusual in Texas. So there's two things in criminal procedure that are a bit interesting. In Texas, if it's custodial interrogation, think police station, although not necessarily. If it's custodial interrogation, in order to use the defendant's statements against them, there must be a recording of it. So if there must be an audio video recording of it. So if there's not an audio video recording, you can't admit their confession against them with respect to a custodial interrogation. So Miranda, right? So if it's non-custodial interrogation, right, they're just asking you questions, before they arrest you or something, then yes, you can use the statements against them from a written record. But in Texas, if it's custodial interrogation, there must be a audio video recording of it. So that's a deviation from the normal rule. So Texas extends that interesting rule. And the other interesting one that was surprising was that the Fourth Amendment applies to private parties, which of course is not the standard rule, right? The Fourth Amendment, like all constitutional provisions, only applies to the government. So if the government does an illegal search, right, we start thinking about suppression. But normally, if it's a non-governmental actor, we don't care, right? Because the Constitution only restrains the government. But Texas, by its operation of its own state law, has said, actually, as to private parties, we do care. So even if it's a private party acting completely independently, if they did something that, if they were police, would have violated someone's rights, we start going through the suppression analysis, just like the same as if they're a public official. So, hey, who knew? Texas extends Fourth Amendment protections to searches by private parties, too. Okay, that's interesting news. So there's something I learned. Explain Texas deadly force and protection of property. I'm not an expert on the issue. I mean, I could go look at the relevant statute. It didn't come up in the training. There is some limited protection to use deadly force in protection of property. I'd have to go read the relevant statute. Isn't it contradictory to be claiming to be a sovereign citizen, but also whining about constitutional rights being violated? Don't think about it too hard. If you think about things too hard, your brain will explode. Nothing makes any sense. Yes, I found the key. I found the car key fob. Thank you for asking. It was under my passenger seat. Took it to a local mechanic, put a mirror under the seat, and was able to find it. So, problem solved. The judge said the recess was going to be about 10 minutes. So we're expecting the judge to come back pretty soon. Don't think about the sovereign citizen stuff. It'll make your brain explode. You know, it's like one of those Star Trek episodes where they tell the robot, I am lying. And it's like, wait, if you're lying, then you're telling the truth. If you're telling the truth, then you're lying. And the robot's head explodes from the inherent logical contradiction. That's what sovereign citizen thinking is like. If you think about the sovereign citizen stuff, you will run into a logic error and your brain will explode. I know, my brain has exploded several times, actually. It's a bad plan. Your brain probably will have a stroke just to cut off blood supply to your brain in some sort of attempt to make you stop thinking, because the brain will think that that's actually like the most preserving move it can do. It's like, maybe if I kill this part of myself, it will save the rest of myself and allow me to keep breathing. So thinking about sovereign citizen nonsense may induce strokes. I seem to remember something from the American Medical Association as a warning on that one. I don't know. Maybe I made that up. They wouldn't encourage it, though. I personally hope that Darrell Brooks is not taking out a gen prop. I hope it, yeah. Interlocution said Texas is known historically for rights violations. I think the Fourth Amendment and interrogation rules are a state's attempt to correct long-standing history of misconduct. Well, I can't really speak to that in particular. I didn't know Texas was particularly known for those problems. I thought that was like more like Illinois and Louisiana, but okay. But either way, noted. So, fine. Yeah. I learned a little bit about oil and gas rights. Yeah. Nothing of interest really there. I learned that getting a forced pooling arrangement is pretty hard in Texas. So in some states, like a forced pooling arrangement would be, there are multiple different people whose land all accesses the same oil supply, right? Because oil is underground, right? And the oil underground may not necessarily cleanly follow the borders above ground, right? So like multiple different people might have access to the same oil. And so like, how do you deal with that problem? And so one of the ways that some states have dealt with this problem is by creating these forced pooling arrangements. So basically, in so many words, like, we're going to force you into like a common, basically we're going to transform your individual leases effectively into like one big ass lease. So we're all forcing you to be part of this common thing that we are going to create that is going to split the proceeds from this in some sort of equitable fashion. And Texas doesn't do that. It's very, very hard to get that arrangement in Texas. It's possible, but very, very difficult. So, okay, that's, if it comes up, it comes up. I also learned that you can get a lien against someone for damage to your fence by operation of law. So, yeah, there's certain so a good example of like a lien by operation of law is like a mechanic's lien, which is very common in most states. You take your car to a shop to get repaired, right? And so the shop does $1,000 worth of repair. And it's like, well, they're going to make you pay them before they give you the car back. It's like, well, you're holding my car hostage, right? You have to give me my car back. Well, pretty much every state, to the best of my knowledge, has these things called a mechanic's lien. It's exactly what it is, right? It's a lien against the car. Or in the same way that when you take out money to buy the car, right? That's also a lien against the car, right? You've borrowed money to buy the car. So it's a secured debt. The debt is secured by the car, as opposed to an unsecured debt, like you just go ahead and buy something with your credit card, right? That's an unsecured debt. It is not secured by the thing. So if you default on your credit card, the credit card company can sue you. They just can't start taking your stuff. If you default on your bank loan for your car, they can take your car. That's what makes it secured, right? They can take your car as a remedy. It's secured, right? And so that's an example. And like a mortgage is obviously an example of a secured loan, right? The mortgage is secured against the property itself. So if you don't pay your mortgage, they get to take your property, right? That's a secured loan. Okay, so those are some examples of secured loans. And then Texas has one by operation of law if you damage someone's fence. So you get a lien against them for the damage to your fence and any resulting expenses. For example, if the damage to the fence causes your cows to escape, you get a lien against them not only for the repair of the fence, but also for the expense of retrieving your cows. So there's a lien by operation of law in damaging someone's fence. I learned that. Is that information that's interesting to anybody? Fence liens? These are the things I've learned. Yeah, if you're underwater on a secured loan, can you walk away from the item? No, they can sue you for the difference. And also the other way around. If you're over water, they have to pay you back the difference. So they get to seize your asset, but they are responsible for giving you any difference, that any profit you get back. And any shortage, you still have to pay. So it's fair both ways. Do I practice fence law? No, I'm just learning that there's apparently a thing that exists. My neighbor's overgrowth on the fence is tearing up the fence. Well, in Texas, you may have a special remedy on top of other remedies. Like normally you can just do nuisance, but on top, apparently in Texas, not only that, but apparently you get some liens or something. Kathleen says Texans are serious about their fences. Apparently, yes. Apparently they are serious about their fences, yes. So Kurt is the only lawyer I go to for fence law. Well, at least in the law tubes, I think I can say that, well, I don't know, Attorney Tom might know something about it, but other than Attorney Tom, I'm probably the leading expert on fence law at this point. Which is, yeah, that's good news. When I'm the leading expert, we know we're in trouble. 499 from Chris says, don't mess with Texas's fences. Something like that. Yes. Whistleblower laws also only protect public officials, not private persons. Texas doesn't have, I think, any whistleblower laws for private persons. Also, I learned that non-compete agreements are valid in Texas, but they have to be obtained by something other than money. Money's not considered sufficient consideration for a non-disclosure agreement, so you have to get something else.
from the other courtroom. I've asked that one of the bailiffs who
I
was
learned
present,
things.
During the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record of.
You're going to have
he
the
did
staff
a,
take the stand just to testify to things they
decibel
saw
reading
and heard.
regarding the audio as well. All right, we have
Yeah, put that on the
Deputy
record.
Kibler, if you could take the witness stand, please.
Yeah, so this is not evidence for the jury because it doesn't go to any fact for the jury to decide. This is testimony
Sir,
for
could
the
you please
record
raise
because
your
again,
right
the Court
hand?
of Appeals only knows what's on the
Do
record.
you solemnly swear that the testimony?
So they're going to
you're about
put them
give
under
shall be the
oath
truth,
so
the
that
whole
the
truth,
judge's
and nothing but the
findings
truth?
have further factual basis. Not that
Thank you.
strictly
Please
speaking
have a seat.
necessary, but it shall cover your ass move, right?
Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down.
Yeah, simple to the
And I'm
point. Just
gonna
get some
have
facts on the
Zach
record,
Tremaine
right? Under
also take the
testimony.
witness
So it's like, you know,
stand. Do you have- I have it on my-
just to you know, get that additional
be,
little thing, like the judge keeps saying, like I'm hearing this, I'm reporting this, but
Please.
just to, you know, cover your ass. Why not get that on the record too?
All right, there is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DB meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can
What,
you
if
tell me
any, drink?
67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any questions from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name.
I'm sure you don't.
Do you know anything about the hearing when someone has hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to.
Shit.
When you refer to
Here we go again.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
Oh, Darrell Brooks. I think on the 1-year anniversary of his appeal being denied, maybe I'll go over to the prison during visiting hours. Say, Brooks, you were a big hit for my show. Lol. Maybe we can do a stream. Hi, I'm Uncivil Law. I'm here calling from the Waukesha County Jail with Mr. Brooks. How you doing, sir? I don't consent to that name. We know you don't. Lol.
Sure.
You are in the meeting now.
Okay, good to know.
I need to get the other courtroom in, so just one moment.
Yeah, but what in fact is the business? That is a good question. Yes. Did you ever find out what the business was? Did you ever find out? We're dying to know. Or does the search continue? How are you continuing? Has the business changed since your conviction?
Well, I have to stop the Polycom, Zach.
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please.
This is not a death penalty case, no.
Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Copy that. We're hanging up. So are you calling again? Yep. Okay, good. Except now both the room systems are out, so hold on. One more.
Is he charged with hate crimes? No. Doesn't matter anyway. He's already nothing matters. He's going to jail for the rest of his life. I mean, it doesn't matter how you slice it. There's no winning. There's no winning. Like, it doesn't
You are
matter
in
what
the
jury
meeting
does.
now.
It doesn't matter what the jury does.
All right, so
Short of
the
acquitting him completely,
record
right?
should reflect that.
Did they find him guilty on the intentional murder or a lesser included? No one
I've
cares.
now changed the
Did they find him
audio
guilty on only some of the
visual
counts and
from
other counts? No one
Polycom
cares. I
unit
mean,
to the use
there's
of
there's
Zoom.
basically no scenario where he
I've
doesn't
called
go to
in
jail
both
forever.
courtrooms, and they can hear from over there. And then I'll do. I just need to get back on so I can get the email. Give me a second. I have to go from double screen to single screen. the way I sign in, but that'll take me just a
Yeah,
second.
Neil,
and
you
then
got
I'll
it.
share
Like, even if you
screen so
get
the color exhibit
1 year
can
for
be
every
viewed
charge,
by
that's 76 years. Yeah, you're right. So
the
yeah,
defendant.
exactly. Like, nothing matters. It's like, it doesn't matter. You could find him not guilty in all the murders and everything else, and he's still go to jail for the rest of his life. I mean, he's facing so many charges in so many different combinations. Like, nothing matters. As long as you find him guilty on, like, basically any of the things, he's going to jail forever. You know? I think he's going to be found guilty on some of the things, guys. I think he's having a tough time here. Could they do a federal hate crime? Maybe. I don't know if the feds have any particular interest
All
in
right,
this, and I
now
don't really
the
care either way.
Court is sharing screen, and the image is being displayed. You see it? Okay, thank you. Any questions regarding that then, sir?
Nothing really matters. Anyone can see. Nothing really matters. Nothing really matters to me.
Me, myself, can hear everything good in the courtroom, correct?
I do not, correct.
Okay.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again,
Yep.
it's all the same, 107 pages, and then my written copy is...
So 2 to 3 hours for reading them all, sounding pretty good right about now. To read 107 pages, yeah. The value for these documents is you're going to jail forever.
I also would like to again ask for subject matter jurisdiction and improvement on the record.
Uh-huh,
The
no.
request is
It
denied.
has yet to be verified. It has yet to be verified.
I don't even know what that means. I don't know what that means.
Your
I
request
don't
is
know what it
noted.
means. I don't know what
It's
lawful
denied.
law is. I
Without
don't know
further
what
hearing or
verification
consideration.
means. I don't know what any of these things mean. It hurts my brain. I've been a lawyer for 15 years. I don't like it very much in terms of what he's doing to my brain. My brain has been now wired through 15 years to think in legal ways, in legally precise ways. And every time he talks, my brain like rejects it like an antibody. I think it's possible that I could be a case study for some neurologist somewhere, because I think it's possible that antibodies don't only exist in the blood. I think it's possible that antibodies exist in the electrons or mylar sheathing of the brain or something, and I think my brain sends electrical signals,
So the
which are
court did
antibodies,
declare
to attack the bad
evidentiary
thoughts.
phase of this trial
I think
closed.
brain
specifically
waves
found
as
that you forfeited
antibodies
your right to
is the
present
basis
any
of a
further
paper
evidence or testimony
that needs to be
when
written.
you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence.
If you're
To
a
the extent
neurologist
that you
looking
wrote
to
all
write
of
a
those
paper,
documents, sir, that would be
please give me a
hearsay.
call.
And for that reason, I'm
You
denying your
could work
request
on
to
the
make them
neural
part of the record.
antibodies thing. It's a whole new science waiting to be discovered.
I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present it to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have
my-
a debate about this
Are you
now.
denying me-
I got
are
to
you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony
Look at me yell.
previously by refusing to answer the court's questions.
No one can hear you.
I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would.
I'm enjoying
allow
watching
this court
him
to
rant
admit
silently. This
his
pleases
written
me.
Filings, I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them. I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that.
All right, guys. Here's the over/under
Talk
bet
about
you guys
whether
can do.
any of the
We need
instructions
some
that are in
mechanisms.
here,
We need some sort of mechanism
need to be modified
in chat
in
to
any
do
way,
bets.
taken out, edited, etc.
The current bet is: will I resort to
You're unmuted
drinking
now, but as long
before
as that you
noon?
have
It is now
to not
10:21.
interrupt.
Will I resort to
You can't-
drinking
you
in the
can't-
next
I'm not
hour,
trying to
40
interrupt,
minutes?
but how can you deny me the chance to put
I'm
on
already
the
thinking
actual
about it,
evidence by
so
saying nothing that
you can
told me
factor
to
that
do
into your
can be presented into evidence. So you filed them. You filed
predictions.
everything that I gave to you. You
Right,
filed.
Mr. Brooks, I'm
And
going
that's
to
all I'm
mute you
saying.
because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified.
We'll do a poll.
I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right,
I
I'll
told
mute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge
Do you acknowledge
receipt
receipt
of
for
the draft
value?
of the final jury instructions?
I don't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the
That's-
bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I done stated
I'm going to
3 or
read it
4
once
times?
again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that.
Oh, you don't? I changed,
Hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, and 172 at the end because they were short.
He's putting boxes in front of the screen. I didn't even notice. Apparently he's building a beehive or something in front of the screen. That's nice. That's a nice. Okay, guys. I think if you voted no on the bet, you guys, it's only been 5 minutes. It's only been 5 minutes, and I'm already. The bottle's in front of me. I'm staring at it longingly. It's not going great over here in Uncivil Law land. Oh Lord, we're in trouble. We're in trouble, friends. The no betters are gonna have to pay up, I think. Oh my God.
He can remain in the other courtroom.
Do you want to build a snowman? Do you want to come out and play? Do you want to block the screen with your boxes so you can't see the evidence? Today, do you want to rant mutely so that you can, but no one can hear? Do you want to build a snowman? A nice tower of boxes snowman. Okay, goodbye.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs.
She
I
can
can't
hear him.
decipher what he's yelling.
She can hear him because he's yelling so loud. That's hilarious. Do you want to yell at nothing so loud that everyone can't hear? But your voices penetrate through the walls of the courtroom, but not very clear. Do you want to build a box fort full of your filing boxes so hard? Do you want to build a snowman? A ranty, pathetic little snowman. Okay, goodbye.
I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom.
Nice.
And that would require him to have a colloquy with me.
Which is not going to happen, so. We're no strangers to love. You know the rules, and so do I. A full commitment's what I'm thinking of. You wouldn't get this from any other guy. I just wanna tell you how I'm feeling. Wanna make you understand. Never gonna give you up. Never gonna let you down. Never gonna turn around and desert you. Never gonna tell a lie. Never gonna say goodbye. Never gonna say a lie and hurt you.
Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Can I show you my soundboard setup? And it's constantly in a state of modification because I'm moving things around, but I can kind of show it to you what it looks like, at least right now. It's just got a little stream deck here. It's what a lot of streamers use. And then you get little buttons for things. So I'm not sure how well that will show up, but you know, I got little buttons for things. So I got button for sounds,
If you
lights.
have specific instructions,
I got a little
or
sub counter there you
categories
can
of
see.
instructions that
So
you
I can see
believe
how
this
my
court
channel's
should
doing. Got
consider, I need you to
113,000
write them
subscribers. Thank you
down
guys for subscribing.
on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
And these, obviously, all these buttons can be changed, and the little icons can be changed. So, you know, we can do like, you know, on this screen, like for example, you know, see the little button for emotional damage up here.
Emotional damage. Emotional damage.
All those buttons can be changed and moved around and stuff, so it's pretty cool. I want to get away. I want to fly away. Yeah, baby. I want to get away. I want to fly away. Yeah, baby. What the hell is happening now in this trial? Just looking through the jury instructions. Just another manic Monday. Ah, wish it was Sunday. Ah, just another manic Monday. "2012, Jamison says Uncivil wants to be bound and gagged by this judge. Hey, don't shame me." Do you have to go through each instruction verbally when the jury is instructed? Yes, they have to read the whole thing. Hey, Salty Mexican, nice to have you here. Nice to have you here, E. Caroline, Brookworm, Becky, Mama C, Power Log, Radioactive Tune. Yeah. What the business? Judge threw me out of the courtroom for my misconduct. What's the business? Not deciding subject matter jurisdiction. What the business? Can't understand what going on. What their business? Pretending not to hear like a little bitch. What the business? Let me send out a notification, see if anyone wants to join wherever this shit show of a stream is. Ooh, what does this button do? Oh. Stop. How do I invite someone to stream? Add guest? How do I invite someone on the stream? Okay, there we go. Alright, so I can send a link. Alright, let's see if anyone on the tubes wants to join me.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom. these should be included, but they just put them in the numerical order. So you definitely haven't taken out any numbers.
Yeah, just the jury instructions. Yeah, so they're going through the jury instructions now to make sure they're good. She's like, I anticipate a long day. I'm not. I'm anticipating we're going to be done pretty soon because Brooks isn't cooperating and the state is looking through it and like, you know, they're going to be like, okay. So yeah, I think they're going to be done before lunch in the way things are going. And why aren't they reading aloud? They don't need to. The jury's not here. They'll read it aloud to the jury when they come back tomorrow. But yeah, so mom didn't show up. Darrell Brooks didn't testify.
Or defendant elects not to testify, and we have to talk about that one. Yeah. Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider.
Closing arguments will be tomorrow.
Please write a note to
Closing
pass
arguments
to
will be tomorrow.
the bailiffs who can let me know.
And then the jury should get the case tomorrow, I would imagine. And I would imagine return a verdict tomorrow. So I think we'll be done by tomorrow evening, if I had to guess. That's my current projection. The jury should get it by lunch or shortly after lunch. Return a verdict, see if they can return it by the end of the day. No, he still seems to be ranting behind the scenes about something. We can't really see it, but we can see his very big ears popping up. We got animation from his ears. I'm sorry, Your Honor. I was wrong. I was wrong this whole time. I've realized the error of my ways. I'm sorry. Uh-huh. Is the instruction about not holding a silence against him automatically included? I don't know which way they default in this court. I don't know which way they default. They probably default to including it. The defense can ask for it not to be read, but I think they default to including it. And I would probably default that way, to default to including it. We can hear the papers because we're hearing them from the prosecutor. The prosecutor's also messing with papers. That's why we're hearing paper. Yeah, the only thing that's going to take the jury time to do is the paperwork for the 70 charges. Yeah, that's about it. How long do I think sentencing impact victims statements? I don't know how Wisconsin does that. If they are going to do that, I would imagine they're going to do it in about a month. They need to give time for notices for everybody. So yeah, that sentencing would be delayed until at least then. Plus, I don't know if there's any sort of pre-sentencing report. Not that it really matters, because, you know, again, there's basically no combination of guilty verdicts that doesn't result in him being in jail for the rest of his life. They could find him not guilty of all the murders and still they'd find him guilty of life. If our new law tube, I jump on Lawful Law as my channel name. Yeah, I thought about that, Abigail. I was like, should I change my name to Lawful Law? Like, should I change the brand? What's my rapper name? I think we at least tentatively said Lawboy Fly, but we might need to work on that because I'm not really sure that that really characterizes me. But that's, how am I finding Melon? I'm liking the fact that it has these integrations Like I can integrate the chat, integrate the super chats and stuff, so people can see them on screen. That's nice, as opposed to having to do it in OBS. So that's a nice to have.
Your Honor, the state has reviewed all 107 images.
Thank you.
How about uncivil lawfully law?
I know upon my review, I noted a few spots that either in the headings, some information or words that might need to be removed. But why don't you go through and tell me what requests you have, starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail, and I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions.
When we do, I'll tell you what, we're at $420 of revenue. If we hit $500, when we hit $500, I'll take a shot. How about that? I'll take a shot for that. That sounds good. Donate money so that I can have a drink.
Look at the information.
Can the appellate court choose to expedite any appeal?
Because I think this was just a
Sure, they can take it out of order.
well,
Your rapper
I
name
guess
must
I'll
be
have
unlawful law.
When we look at the verdict forms on page 102 to
That'd be good.
107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
Yeah, I'll take a shot at $500, and I'll take a shot for every $100 thereafter. That sounds fair. How many times can he appeal? Once. He could ask for writ of habeas corpus, but that won't be granted either.
My computer's just acting up a bit, so I'm going to search. I want to see what the information says. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the...
Yeah, they're discussing instructions for the jury,
changes
right?
are
They're discussing
requested, and
the
then
instructions for
we'll
the
go through
jury.
One by one, but so
And I don't
first is
believe it
page-
was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
Thank you. It's not Brandon Lesko. It's
So that
cute.
would
Nice
be
name.
page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury, but
Okay.
let's go through the list and then we'll get
Okay.
the defendant's responses if he would like to give us those, but we'll go through the whole list. So that's the
then-
bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
Right.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was.
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
Closing arguments for tomorrow. Brandon Lesko gives an not Brandon Lesko gives another $20. Thank you very much. We're getting close. We're getting close.
All right, I made a note of that. Keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify.
Well,
he did have one prior conviction.
There was a PayPal donation.
The witness for the defendant testified that he had a number of convictions.
Okay. Yeah. All right. So I owe him 100. I owe him a shot.
Page 106 of 107, instruction 141, where identification of defendant is an issue.
Once I hit, I owe him a shot.
I don't know if it is an issue.
I'll do that now.
That wasn't raised
All
during
right.
the defendant's closing arguments.
I'll do shot one when we hit the
I'm
next
sorry,
$20.
his opening arguments. I would note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given.
Cheers to you, my friends.
On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, just gonna find it. All right.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Boozy Bucks.
Those are all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks.
I mean, how often will prosecutor experience a trial like this?
Is whether
This is novel for everybody, man, at this level.
any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, because I can see the outline of his arms, and I can see the jacket on the back of this chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
So jury instructions, which you thought would
Your
take
Honor,
all
would it
day,
be
are going to be
possible
done
for the
by
bailiffs to just
lunch.
Move the boxes off the table so
Yes,
we
I
can
think
see.
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Do we want to know? Guys, if this turns graphic, I just wanted to let you know it wasn't
Write it
me
down.
or
He
my
hasn't
fault.
heard him in a while. If you could move the second one, because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests
Take
as it
boxes.
relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my body?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests
Guys,
as it relates
guys,
to
I
the
need
jury
another
instructions?
$14,
Any
please.
additions,
Guys, I
deletions,
need
edits,
$14,
or
please. I
otherwise?
beg you.
You don't gotta
Please.
talk to me like that.
Please, I need it. Please.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Oh, shit. Here we go again.
Mr. Brooks, do you have any
I'm
requests?
tired of my rights being trampled on here too.
Thank you.
I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up there and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Oh my
Then you
God.
should put the
What about
headphones
that
on.
don't you understand? What about that don't you
Oh,
understand?
shit.
You see
Here we go again.
You see everything. You see
No, God! No,
Have you
God,
asked
please,
for headphones
no!
to be
No!
provided, sir?
No!
I should have to ask
No!
I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing.
God's cool with this.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
I'm an authorized speaker for God, and God has no problem with any of this. I just would like you to
So
know.
which one is it?
God told me, and I'm telling you,
What are your
God
requests as it relates?
says He's cool.
What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you.
Bruh.
I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with?
Bail jumping is a new charge.
The Fifth Amendment says that you can't place somebody in jeopardy of life and limb
I'm gonna need more money.
twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
It's surprisingly cogent.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping.
This Darrell Brooks theme song was brought to you by Uncivil Law.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21, 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instruction?
Yay, we passed the next $100 threshold. Yay, thank you.
You can charge twice with the same thing. You can't charge me in pursuant to
You guys are the best. Thank you.
that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
That's 3 shots down. I think there are 20-something in this bottle.
It's two separate cases, sir. There's two.
Is it that 971.23? Is it that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. There's separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests?
Thank you,
do
Frank,
have,
for
sir?
saying I'm getting better at grifting. I am working on it.
Like you don't want me to talk over you. Just like you don't want me to talk over you.
I'm down for all the
Mr. Brooks,
grifting.
what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted.
I think it's time for some sexy sax music.
Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests.
Thank you, Salty
Not
Mexican.
debate with
I like the hat,
me about
too.
prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bail for. The same exact thing. The same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay. Yeah.
Any other requests, sir?
You talk a good game. You talking big game to say
Go suck a dick, suck a dick, suck a motherfucking dick. Suck a dick, suck a huge or small.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154, summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to
Thank you, Justin Map, nailed to the wall, for your
61.
map-related comment. That pleases me. Thank you for everyone who's super chatting, by the way.
I considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There is evidence, of course, that was received regarding the two separate cases out of Milwaukee County.
He's rebuilding his fort. Whoa.
The bail jumping counts. It will be up to the jury
Whoa.
to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions. That obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, "At times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner." What's the state's position on including that but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side, and if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there. You can't see me. I'm putting them there for a reason. It don't have nothing to do with her being able to see.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again.
That was
It's
easy.
unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your
Oh,
verdict in any manner.
DJ K. That's just a great comment. Oh, I need to put that up on screen. Hold on. DJ K. This is a good one. DJ K 217 says they can't convict me if they can't see me. You know what? That actually explains so many things. If this just that goes to show how much of a child he is, because he's such a child. He doesn't understand object permanence yet.
325 impeachment of witness.
Now, if my memory of childhood development is correct, and it's been a while, but I think most children learn object permanence around age 2. So I think he's younger than that. But it explains so many things.
Of a crime, there were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply
Yeah, like
tell
18 months, I
bailiff
knew something
and
around the
tell me
time frame.
and I can unmute him, but unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly.
If he can't see them, they can't see him?
From Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions.
Oh, I agree with you, Wolfie. He's definitely a competent
This is the
dick. I mean, I
instruction on
agree.
identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been.
Is the appeal court able to watch this
discovered
trial
in
back?
case.
Typically, the appeal court just goes on the
Yes, sir.
writing, which is exactly why the judge has to state so many things. Because the court just goes on the writings. Why she has to state things, like, for the record, like, he's doing this, he's doing that, because it has to be in
Depends on what
writing.
you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say.
Why won't the judge find him in contempt? There's no point, Jim. She has nothing to hold over him by finding him in contempt.
Mr. Brooks, I'm going to mute you.
There's no
Unless you
point.
can participate in what we're doing.
She has nothing.
which is
She has nothing to
discussing
hold.
jury
She has nothing to
instructions.
hold over him,
I'm not gonna.
and it would just delay the trial. There's nothing to. There's nothing to do there.
I'm gonna tell them what hasn't been told to me.
Then you won't be allowed to make a
Mr.
closing
Brooks,
statement. So that'll
I'm
shorten
going to mute
things.
you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment.
So she recognizes the difference between flight and escape. So that somewhat validates my very old discussion on the whole thing from
And then I've reviewed
Georgia.
154.
So,
I believe that's appropriate.
yay. Check my emails? Okay, I might as well check my emails as long as I'm sitting here, see if there's anything going on over there. Let's see what's going on in email land.
So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
Ooh, a disposable vape wants me to promote their brand. Exciting.
The formation.
Probably pass on that. I'm gonna block his email because I don't like him. Goodbye. Yeah.
Do you have the exhibit list, Madam Clerk?
Ting Ting, that's not my name. That's a
What
good
are
one.
those
That's a good
numbers
suggestion.
again? I wrote 141.
We're just looking for the extreme dance and
Greetings. My name is Angelina. I'm the advertising represent for Crypto Kitties project. Crypto Kitties is one of the first blockchains using NFTs. Blockchain games.
extreme dance team.
So
I think we'll be
54,
passing on Crypto
141, and 33.
Kitties.
Yes.
Do you think the use of the word chart is correct?
From
or
Cherry
should that
Team.
be-
Looks like an email from Cherry
I
Team
would say
because it is.
diagram and map.
We're here to make you a good offer. Our offer is an integration of about
First of all,
60
the use
seconds
of
video on your channel.
Diagrams and maps to organize the
Have you heard about Hollow
Maps
Knight?
for evidence, though.
It's a cool video game for any age, and now the second part is ready as well. It's called Hollow Knight. It's called Hollow Knight, the Silk Song.
And to assist you in understanding
I
it.
think
The
we'll be
chart
passing on
itself
that
is
one
not
too.
evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So,
they were all admitted.
They were all admitted based upon.
The jury's not here,
what was
Logic's
presented
finest.
and the
I apologize.
testimony regarding them. Typically, where that comes in is for
Hollow
use
Knight is
in
amazing.
openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think
Hollow Knight is cool.
154 is needed, and I'll deny that request. What about 152 regarding the view?
As I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't
Okay.
believe it goes
All right.
into
I'll
the
respond back to
closing
them then and say, okay, we're
final
interested.
instructions.
That
would
was
be my position.
my inclination, but I wanted to
We'll respond to the Hollow Knight people.
get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in here. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even during this time, though, you've been incredibly disruptive.
I can't say that.
At one point you were muted for an extended period of time and you were yelling so loud, sir, we could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk.
No, it's a spam email from it's not a legitimate email
again.
from it's not a legitimate email, it was a fake.
She has been working on the verdict forms,
So
which are
no Hollow Knight,
approved by this
no
court.
Hollow Knight news.
So
unfortunately, it was a
off.
fake.
A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form, so all of the jurors were made aware.
Excuse me, please. One more drink.
All of the instructions.
Could you make it strong? Because I don't need to think. She broke my heart. Gracie's gone.
Deliberating.
One more drink and I'll move on.
This afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdicts, and then you can leave for lunch. Thank you.
All right, guys. Well, that is going to end our stream for the moment. I know you're disappointed. But I'm going to pop on with Legal Bites because she's doing some stuff now, and I promised I would appear. And now I would like to do that because, I'm free. So I'm going to take 5 minutes, pause for myself, and then I will be over with Legal Bites. And then we'll probably be back this afternoon with some more streaming because that sounds hilarious. But this stream will end for the moment. But let me go ahead and read the super chats because I have them all recorded, and I'd like to do that before I head off. I know I read some of them, but I'd like to read all of them because that's a polite thing to do. Okay. So let's see. Where are we? We are on the 24th. So let us read some super chats. Very exciting. The super chats start here. Glassbell asked, will Farrell's mom show up? Will Farrell take the stand? Find out next time on another exciting episode of Dragon Ball Z. The answer turned out to be no. From Drenkin. Didn't he say that when he tells his mom she'll show up, she will? Lol. Apparently not. No. From $10 from Projects Done Poorly. Is Brooks a product of nature or nurture? I don't know. Lisa McKay said, Kurt, please watch 9:19 from Friday. Drenkin said, can his arguments and objection be distilled to the evidence makes my excuses look bad? Not a wholly unreasonable way of doing it. Tina Lewis said, if this recall is a factor, wouldn't the improper tire show negligence of proper vehicle care affecting warranty and recall? Well, anything that would show the vehicle is not operating properly obviously could be a mitigating factor potentially, or potentially an excuse, right? So to the extent that he would know about it, well, it wasn't his car. So that goes a long way, right? It wasn't his car. So like if the car is not operating properly because of some problem, then he may not even be on notice of it at all because it's not his car. And even if he was on notice, like might not necessarily be his fault. And even if it was his fault, it could be a mitigating factor. So like, yeah, the problems the car has could be relevant at every possible stage. It could be relevant as to a legal thing that would prevent a cause of action. And even if there's guilt, it could mitigate punishment. So it's definitely relevant, at least arguably, right? It could be completely bollocks too, but yeah, it could fall anywhere in that spectrum. Pinocchio's helicopter tours, or Pinochet's helicopter tours, which is even more hilarious, said, I recall 4 other people's Hondas all the time. I get recalls for 4 other people's Hondas all the time. Gromobot said, hi from Singapore, where we don't have a jury, and therefore not much entertainment. Sophisters get laughed out of here all the time by the judge. That's funny. Zachary McPherson says, judge wants a recall on her sanity after this. I feel that. Timmy, or T-MMY, said, if he's a sovereign citizen, how can he expect any rights in the U.S. Constitution? Don't think it'll make your life better. Sandra said, tase him, please. I feel that. Lisa McKay said, you quit watching too early on Friday. Maybe we'll watch that later. Theresa said, thank you for legal education, love, and Aussie Losting. Well, thank you. I love you too. Jake gave $99.99, say happy belated Texas bar passage, and thanks for all you do. Thank you, Jake, for that very generous super chat. $5 from Gates of Above. As a lawyer, you should know holding the Bible is an automatic not guilty card. I missed that memo, I have to say. Daniel said, why don't we just give judges the authority to find a defendant like this guilty as incentive to cooperate? Because it would violate the Constitution. Because, you have to prove your case, prove your guilt. Because, the power would be abused is basically the actual answer. But, yeah. 2 days from Amy in Boston. Thank you for making my day of programming tolerable. You're welcome. Andrew Hansen said, I trust my 8-year-old nephew as a lawyer before this guy. I think you might be better off. Walter Melton said, Uncivil Law has promised the business. This is not the business. Where's the business? The business is coming in the form of prison guards batoned, I think. Just a Small Town Girls gave $9.99, said, thanks for covering this. Katrina said, Kurt, I admire your intelligence and perfectly execute comedic timing. Thank you. Florida Dad said, just checking to see what it would look like if he had no money. That's good. Castle gave $4.99 to say, Jesus wept, this trial is wild. Colin said, just answer yes or no for once, damn it. Daniel said, thanks for your coverage, Kurt. Drexen said, he's trying to stall by getting her to start the dance of sending him out and back over and over. Possibly. Carolina said, if Brooks had stuck with not guilty by mental defect, what would have been different? Would sentence been the same but mental institution? If the jury believed it, yeah, he would be held until he was cured, which can be an indefinite sentence. But in his case, I suppose he'd be better off. Maybe. It's debatable. Just because says mental institutions are not necessarily nice places either. Just because said $5. Darrell Brooks will be playing the role of Van Cum Lady on today's Mad TV. La la la, I can't hear you. Colby said, what do you think, Kurt? Could he get a new trial? Did the judge do enough or not too much? The judge is fine. The judge is bending way over backwards. The judge is doing way more than is required. I've seen nothing during the trial itself that's an appealable issue. So, I wasn't following this case super closely, and I think my sanity thanks me for that, by the way. But if there was something pre-trial, maybe, but I don't see any appealable issues from what's happened in the trial itself. The judge has gone out of her way. Dennis said if he does choose to testify, will it just be cross-examined? No, he'd be allowed to give some sort of statement or narrative, but it didn't happen. DBD said, Judge Mommy grew a pair over the weekend. Wonder who told her to stop letting him walk all over him after Friday's cross. Judge Mommy definitely was a bit more assertive. Maybe she's just reached her limit. But even she's still well on the side of her discretion. So she's a little harsher, but she's doing fine. Terraria said, I was going to ask how will the appeal court deal with this, but I just think you answered. Mostly by drinking, I think, is the answer for the appeal court. As the appeal court, I demand my normal fee, and I also demand a bottle of bourbon. That would be it. Like, I don't know what the court of appeals typically charges for an appeal, but I demand that plus a bottle of bourbon for dealing with the stupid. Lauren said for $5, if he doesn't testify, can the DA call him on redirect? No, they can't. He has to waive his right. And there was no redirect, so all stupid. Detective Seeds gave $10 to say congrats. Folks got to see a sovereign citizen strategy in court. If you want some company, I'll be on in a little bit. And he said, any chance he can appeal just because Wisconsin's so woke? Not a chance in this world. Grail said, thank you for your knowledge and opinion on appeal. Yeah, he's going down hard. The Court of Appeals will laugh in his general direction. I look forward to that day coming. That'll be fun. Joseph asked, explain Texas deadly force and defensive property. We don't have time for that. It's by statute and it's limited. Interlocution gave $10 to say his Texas is historically known for rights violations. I think the Fourth Amendment interrogation rules are the state's attempt to correct their long-standing problems. Chris gave $9.99 say, fun fact, the Texas Railroad Commission is a regulatory agency over oil and gas production and transportation, including pipelines, and has very little to do with actual railroads. Okay. Sam Seelman says, thank you for the coverage. I really appreciate your analysis and congrats on Texas Bar Cheers. Pussy Cat said, I'm so conflicted. On the one hand, I'm glad this judge finally followed through with the threat. I love seeing him completely undone about it. But I was also really looking forward to state's cross-exam. The recess said, we basically have no rights in Australia, so I've heard. Christine says, I'm confused about what a sovereign citizen is. Don't ask questions. It only leads to silliness and confusion and mental impairment. Don't ask. Kathleen says Texans are serious about fences, apparently. Chris said, don't mess with Texans' fences. Michael said, could they charge him with a federal hate crime to get death penalty? I suppose they could, but at this point, I don't care. Joshua said, Kurt will be in a drunk nap by 3. That's quite possible. Jason said, now his defense is blind, deaf, and dumb. $5 from Neil Pearl, who said, cheers. $9.99 from Gina Faust, who said, cheers. Dear Amy gave $9.99, said, has anyone asked Mr. Brooks what name he does consent to be called? Yes, and he gave a nonsensical answer, which should surprise nobody. Lady Bethany says maybe he wants to play peekaboo. Gay Gold Chaos says, when is the album dropping, Kurt? 10 out of 10, we'll buy. It needs work. It needs development, but you're seeing some sort of ideas, at least in the development. $2 from Daniel, who said all the public defenders called him sick. $1.99 from Rainbow Bright's Evil Twin, who said, can I show you your soundboard setup? I did that. $1.99 says, is it really just 10 minutes in on Monday? It was 10 minutes into me making the bet as to whether or not I'd make it 90 minutes. It didn't come to pass. I fell short. Interlocution said, I wonder if the judge is laughing him in her head as much as we are. 2012 Davidson said, Uncivil wants to be bound and gagged by the judge. Don't judge me. That's not fair. Sage V says, so if the jury instructions, that's left, yes. And now the verdict forms, but that will be this afternoon. Rainbow Bright says, why aren't they reading aloud? Isn't the way it's normally done? It will be read aloud for the jury if the jury's not here. This is just the lawyer's chance to discuss what will be read to the jury tomorrow. Michael said, do you think he did the box for to hide his yelling? I think he did it just to be petulant. I don't think it has any more complicated than that. Mallow Man said, D. Brooks, I want a blankie to finish my fort. Don't we all? Garrett said he's a sovereign citizen of Fort Court documents. Lost and Found says, I'm sure I missed it, but what's your rapper name? We're working on it, but we've had some nice ideas from the chat. Bailey said, can an appeal court choose to expedite any appeal? Yes. Could the victim's desire for swift closure be taken into consideration? Yes, they could expedite this. And it's a criminal appeal, so criminal appeals are usually handled faster. So, yes. It's not Brandon Lasco said, it's such a poor life choice, but I'll take it as tacit agreement. I accept for value and return value. Let's try one on. $5 from Courtney Shelia. Here's to you taking a shot as my proxy. It's not Brandon Lasco said Uno. Quad 8 said, would it be fair to ask what the business? Is that a lawful law? Digitalis said, boozy box. I made a pun. Drink to make the pain go away. Also, how many shots until you switch to disco? Maybe this afternoon. Han said, how often will a prosecutor experience trial like this during their career? No. In traffic court, maybe, but nothing like this at this level. DBD said, I want a box for it now, so do I. Just a map nailed to the wall said, sir, your cheeks will be taken soon. That's why we're taking the box so you get assimilated. Funny. Sparhawk Gaming gave $14 with no message, but thank you. Catman gave $10 to say, here you go. Interlocution gave $14 to say, I need a drink. Just a map asked, was God a sovereign citizen? Yes. Sarah Beth says, why aren't they shocking him? He hasn't been physically violent is the reason why. He hasn't posed a danger to himself or to others physically. He's been petulant, not violent. Red Scar said, it's going to be difficult to top this court case for entertainment value, but I'm sure someone will try. I'm not sure how entertaining this is, but okay. $2 from DBD says, Chimp goes, aha! Just a map said, can I get it out? Brooks in prison for the next 50 years. Shelley said, is your sound machine dating Brat? Sleeves N said, at this point, this is the monster she has created with her numerous foul chances and indulgences. A little bit, yes, but he's definitely responsible for his own conduct in any respect. Just a map said, are you going to cover this entire travesty until it's over? Well, it's over pretty soon, so probably. Manders gave 13, Manders 13 said, towards the drinking fund, love the new display. Thank you. Just a map said, a map, 2 maps, 3 maps. No wonder why he drove through the parade. Red Scar said, the return of the box fort. Red Scar said, no, mean old judge, we stand the box fort. Cute. $2 from Kathleen, who said, actually, if you can't see them, they can't see them. Dr. Spoon said, and he hasn't been tased since the COVID test report. Pirate Grace gave $1.99. MK gave $10. No messages, but thank you. Red Scar said, Hollow Knight is an awesome game. I'm excited for the sequel. Well, apparently it was a scam, because the email bounced, but, maybe next time. Pirate Grace says, thanks. Your edition of What Do You Want to Build a Snowman sent me into full-blown lulz. You missed your true calling. Mo Zamboni said, hey, Kurt, I used to work for Joe. Good logic of video thumbnails. Check your email. Well done. Auto-tune was on point. Thank you. Shannon says, how come some states in cases are called by name and others aren't? Example, Illinois versus Allen and the state versus Anthony. Don't know. It's just the way that those individual states like it. There's no real reason beyond it, to be honest. Thor Theo said, imagine being no-showed by your own mom. Lord of the Brain said, I don't know what you're talking about, lawyer. If the box fort is built, you can't find guilt. You can't prove you can hear anything. Kiwi New York Upstate said, I do not consent to my YouTube username. You shall not read it. Lord of the Brain said, this judge, last time I saw someone ran over this badly, I was in the Christmas parade. Why is no one talking about the great performance of that truck? That is pretty dark and hilarious. And is that the end of the super chats? Let me just scroll to double check. Yes, excellent. All right, so those are all the super chats. So I'm going to sign off. I'll be on with Legal Bites, and I'll probably be back on this afternoon. For the 1,600 of you who are here, thank you very much for being with me for this live stream. I've appreciated. If you have enjoyed the stream or not, either way, give it a like or give it a dislike. I don't care. Either way helps the engagement. Like it, dislike it, whatever. Hit the join button. Hit the subscribe button if it's red. Do all the YouTube-y things, all those good stuffs. I'll be on later today, I'm sure. Until later, my friends, until we get to the jury instructions portion of the pain, I've been Uncivil Law. Until later, I hope all is well. Cheers, my friends, and goodbye.